All right, hello, good afternoon. My name is Eric Hauge. I'm Executive Director of Homeline, and you are joining us today on Wednesday, July 14th at 1:30 in the afternoon for another one of our webinar events in the series regarding Minnesota's eviction moratorium phase-out or off-ramp. Thanks for joining us today. Couple pieces of logistics before we get started. And today we'll be joined by both Rachel Sterling, who is Homeline's COVID-19 Eviction Response Coordinator and a housing attorney, and our Managing Attorney and Hotline Director, Mike Braw. And a reminder for any folks who are joining us, new folks joining us, Homeline, our main program is a free and confidential statewide tenant hotline that advises around 15,000 renter households per year. And we have services in English, Spanish, Somali, and Hmong. We also have staff of organizers, public policy advocates, and we rely on volunteers and interns to serve the community. Today, and here's our hotline number, and you can also email an attorney on our website. Before we get started, just and I'll put some links in the chat for this information, but we have published on our website a visual timeline, some key points in an FAQ document about the Minnesota's eviction moratorium phase-out. We also have information about our webinar series on our website there, and all the recordings going back to April of last year when we started doing webinars about COVID-19 issues are on our website at that link. Our current webinar series is focused on the eviction moratorium phase out, and we have dates scheduled and registration set up going into mid-August. August 18th is the last one scheduled, but we'll probably extend that as things proceed. But just the next couple weeks, we intend to have a couple of guest speakers. Next week, July 21st, we'll do again another overview of the phase out, but we intend to have a guest speaker, at least one guest speaker, either from Rent Help MN, Minnesota Housing Finance Agency, or someone from Housing Link to discuss their zero balance project. Those are the two COVID-19 emergency rental assistance programs that are specifically referred to, cited in the phase out law, and are the programs that protect, if a tenant has a pending application within either of those programs, protect tenants from evictions for non-payment. So we'll have some folks on speaking about those programs next week. We will send a blast email out to participants today and attendees of previous webinars when we confirm our guest speakers. And then the following week, 2 weeks from today on the 28th, Kim Tennyson, who's been on several of our previous webinars this year and last year, will be joining us to discuss the phase out from a landlord legal perspective. Kim is an attorney that regularly advises and represents landlords. Looking forward to that too. But again, before we get started, we'll again just remind folks about those two programs I just mentioned. renthelpmn.org or dialing 211 is how tenants can access the application for the COVID-19 Emergency Rental Assistance Program that is statewide. We strongly encourage tenants to do that. And if the folks have questions about that process, dialing 211 is a way you can get connected to a field partner who can answer questions and help you with that process. And then also the Zero Balance Project had been open last month, I think, and then had to close, but it's reopened now as of Monday of this week. And again, the Zero Balance Project is can be accessed through Housing Link's website. It is only for the counties of Dakota, Hennepin, and Ramsey. And it's a program, it is a COVID-19 emergency rental assistance program that landlords can initiate the application process. So that's another option for landlords in those counties. Tenants will then receive information about that process and will have to complete part of the application too. All right, so with that, I'm going to hand it over in a minute here to Homeline's managing attorney and hotline director, Mike Fra. We did get a number of questions submitted in advance, just a few, but we're happy to field questions at the end of this this presentation. And both Mike and Rachel Sterling, housing attorney here at Homeline, will answer questions, and I'll stick around too in case I can help in any way. But please, if you do have questions, submit them over the Q&A function in Zoom. And with that, I will send a few things in the chat regarding some of the resources that we just talked about, and I'll hand it over to Mike. Thanks.
Thanks, Eric. Nice to have you back again. All right, let's get started. What we're going to talk about at the beginning, as we have been doing since April of last year when we started doing these presentations, is sort of a status update. Here's what the law is, here's where it's headed, the parts that we know for sure, and a quick look at what we think is coming as well. So to recap, the executive order that had an eviction moratorium built into it, Executive Order 20 from 2020, number 79, is over. The eviction moratorium is officially ended, tied into the governor's peacetime emergency. That eviction moratorium was, by virtue of the peacetime emergency, extended 15 times in total. So it was around for 16 months that it had been renewed. But it ended when there was a legislative agreement signed by the governor. So both the Senate and the House agreed on a law that the governor signed, that was signed on the 29th of June and went into effect on June 30th. And we're going to talk now about what that session law, it's not technically a statute, what that session law has to say. So go ahead and roll the slide, Eric. Okay, so we are in what we have termed phase, well, not phase one, phase two today. Phase one ended officially at midnight last night. It nullified the governor's order, like I just said, the eviction moratorium order that had been in place for since March of last year. And it replaced it with this off-ramp. And so here are some of the current rules that we still have in place. Now, how the phases work is landlords start to gain rights back in each phase. And once we're done with phase one, go into phase two, all the rights the landlord had in phase one are still intact. They just add more rights in phase two is probably the easiest way to sort of understand what's happening as we go from phase to phase. Because we're in phase two right now, that doesn't mean that phase one is obsolete. All the stuff that a landlord had built into phase one, they still have. They'll just have more ability to do things because of phase two having started. So phase one, what it says is that the landlord can evict for some exceptions. Here we are with the list. Seriously endangering others. This is the tenant seriously endangering others or causing significant property damage, or violating Minnesota statute 504B.171, which is the no illegal drugs, illegal weapons, prostitution, etc. on the property rule. Now, 504B.171 predates the pandemic by 30 years or so, 25, 30 years. So that's nothing new. The endangering others and the property damage are leftovers from the executive order that we've had in place since last year. One part of the executive order, a landlord was allowed to terminate a lease or file an eviction ultimately if the tenant wouldn't leave, if the landlord or a family member needed to move in. That exception is no longer present. A landlord can't use that exception anymore to make a tenant go. It was among the more popular approaches for landlords that were thinking about filing evictions during the pandemic. This was one of the few ways they saw that they could make a tenant leave. And so they would use that exception if they were planning to move in or their family member was planning to move in. Added to that list is the first non-payment of rent possibility that landlords have had in over 16 months, but only if the tenant is overdue on rent, behind on rent, and refuses to apply for help through Rent Help MN. So that's the lone non-payment of rent case that a landlord could file under phase one. Additionally, under phase one, the landlord was allowed to give a notice to vacate or terminate a lease, which is something like a piece of paper, typically. Hey, tenant, leave by the end of next month, or I'm going to file an eviction for holding over. And the reason why I'm making it go is because you have violated a term of the lease, a material term of the lease. What's a material breach of the lease? Well, there's a couple examples that I can give you that typically tend to win for landlords. One would be an unauthorized occupant. So that's a girlfriend or boyfriend or maybe a family member moving in with somebody, or maybe an unauthorized pet. Those are two of the ones that typically are winners for landlords when they file material breach violation cases pre-pandemic. We'll see whether landlords are filing evictions for those reasons or not very soon. It should be noted, and this is going to be an overarching presence through most of the stuff we're talking about today, that during the first 5 phases of the eviction moratorium off-ramp or phase-out, whatever you'd like to call it, if a landlord wants to file an eviction against a tenant for non-payment of rent, they have to give a notice, and we'll go into detail about what that notice needs to look like in a little bit. And then additionally, through June 1st of 2022, a tenant is protected from non-payment of rent evictions if they have a pending application in with Rent Help MN. And so that's a couple of catch-all safety nets that are in place for tenants, both relating to non-payment of rent issues. And so, like I said, we'll talk about those more as we get to them. But let's talk about phase 2, which started at midnight last night. So here we are, phase 2. So evictions can be filed for a material breach of the lease. Okay, didn't I just talk about the material breach of the lease? Yes, I did. But I was talking about a notice to vacate or a notice of non-renewal or a termination or a notice to quit. They go by a lot of different phrases. They're not all interchangeable, but they're all pretty closely related. But those are all a piece of paper from the landlord to the tenant, or sometimes even an email saying, hey, you've got to leave by a certain time or else. Okay. The or else almost always is, or else I can go file an eviction against you. And that is a different allowance now that landlords have. They can go file a court case, an eviction against a tenant for material breach of the lease as of, again, midnight last night. Will landlords file a lot of those evictions? We're not sure. We get a list of all the evictions filed each Sunday night, and so we'll have a better sense of what the response was from landlords and whether they took advantage of this ability. I can say that this is something that's been in letters to the editor, online, and certainly we've heard it from landlords both on these speeches and in other places that they've been waiting to be able to file an eviction for material breach of the lease. That they've put up with tenants for months, if not over a year, that were doing things that were violations of the contract, bothering neighbors by smoking in a non-smoking building, making a ton of noise, having a pet when they're not supposed to. But in pre-pandemic times, evictions were filed. There's 13 to 20,000 residential evictions filed each year, roughly. And that is a wide range. I realize that. When an eviction's filed, it's not always a residential where a tenant lives, their home eviction. Sometimes it's a commercial eviction. If somebody's not paying their rent in a strip mall with their small business, they'll have an eviction filed against them, and it shows up in the same calendar, just like a residential tenant. The last step of a mortgage foreclosure is an eviction as well. So it's hard to say precisely how many residential tenant evictions there are each year. We can give decent ranges, but it's somewhere in that 15 to 20,000 range. And well over 90% of residential tenant evictions in Minnesota are filed for non-payment of rent. And that number fluctuates slightly throughout the years, but it's a pretty accurate statement. Over 90% of evictions are filed because the tenant hasn't paid rent. Assuming that that's still the case, that landlords would still want to file an eviction, because a tenant hasn't paid rent, for the most part, landlords still can't file those. It's only if the tenant is essentially actively refusing to apply for rent help assistance. And so the non-payment case door is still locked for landlords, for 99% of the cases, most likely. The new door that opened is the landlord can go file for material breach. But what if a landlord has a case where a tenant has materially breached a term of the lease, but they also owe a bunch of rent? What does that landlord do? And that's the question that landlords and landlord attorneys have to try to answer right now. Okay, we can go file an eviction because they brought in that dog. Should we do that? They also owe me 8 months of rent. How am I going to get that 8 months of rent? Is there any way I'm going to get it if I file the eviction? Landlords are having to ask themselves that question and then ultimately answer it too. And the odds of a landlord getting 8 months of rent, 10 months of rent, 16 months of rent, whatever it might be, if the tenant is forced out through an eviction case, are pretty low. If you're a landlord, you've been doing this a while, you know that it's not necessarily the best bet to try to chase an old tenant for a debt, even if it's a debt that they clearly owe. A landlord's options would be to take the tenant to court, probably conciliation court, which is pretty inexpensive. It costs about $70 to file, and you can sue for up to $15,000 there. So that sounds easy enough. And the actual act of filing the case and even going through conciliation court isn't that difficult. But collecting the money afterwards, that's a different story. What if the tenant's moved out of state? It becomes more difficult then. What if they don't have any money? What if they just kind of disappear? Some people die, right? That happens. So the landlord's odds of getting that money, if the tenant is gone, go down substantially. And I think every sophisticated landlord in Minnesota realizes that. There are, of course, a lot of landlords that aren't sophisticated, landlords that know every in and out of the landlord business, because it's, I'm not saying it's a hobby, but it's a side profession for many landlords throughout the state. They have another job, a full-time job, and they have a duplex on the side that they're renting out or something like that. That's a very common story in Minnesota. And so will those landlords be able to figure out my best chance of getting money is to try to work with the tenant through Rent Help MN as well. I didn't even mention probably the single most likely reason why landlords won't get money if they chase the tenant out, which is the tenant would file for bankruptcy, which might eventually happen and make it really difficult to collect the debt, if not impossible. And why the eviction isn't going to help the landlord get money is a couple things. Number one, an eviction is just about possession in Minnesota. That's what the landlord wins. I've always said that the easiest way to understand what happens in an actual eviction hearing is that the landlord and the tenant walk up to the front of the room and they put the keys to the rental unit on the bench, the judge's bench, right? And then the judge gets to decide at the end of the case who gets keys. Now, sometimes the tenant will get a temporary key that'll only work for 7 days or something like that. But the judge's real job is to decide who gets the keys. Now, sometimes the tenant wins these cases. Well, they don't really win it. They kind of settle the case by paying up everything they owe. It's got a legal term. It's called redemption. They pay the rent, the late fees, the court costs, whatever other debt that they might owe. They're caught up. They get to stay in a non-payment of rent case. So then they get their key back. So does the landlord. But the eviction court doesn't award money to the landlord. They don't even give a money judgment to the landlord. The landlord has to go to a different court for that purpose. And the other real hurdle the landlord has to try to collect this money, if they successfully remove the tenant through an eviction, is that the programs so far, the Rent Help MN approach, is to not pay old debts, only for current places where the tenant is residing. And so keeping the tenant in the place financially, in a lot of cases, is going to be the landlord's best move financially. Now, landlords will have to overcome quite a time where tenants weren't paying the rent. And you'll have to trust us when we say we've heard the stories, landlords talking about tenants that couldn't pay their rent, but they're driving around the parking lot in a new car and showing off their new phone and stuff like that. Are there stories out there like that that are true? I'm sure there are. Is it every tenant? I don't think so. I think a lot of people have been struggling and suffering. And landlords have been upset with tenants because, well, they've just stopped communicating too. And I understand why landlords would be upset about that. I can also understand why tenants stop communicating. This is going to be a common story that we're going to be hearing on our hotline for the next 9 months, 10 months, and beyond probably, where the tenant got behind and maybe they were even making partial payments. They lost their job, and so they weren't bringing in the income they needed. And they honestly stopped keeping track of how much they owed because the numbers got so big so quickly that they didn't think they could ever catch up. And so what was the point in talking to the landlord if they didn't think they could get caught up? The landlord wasn't going to take a partial payment, so they might as well just, not answer the door when the landlord knocks or not answer the text when the landlord texts. That's happened a lot, and I think it's soured a lot of relationships between landlords and tenants. That's the really bad news. The really good news for those relationships is, well, there's a giant cargo ship full of money in St. Paul waiting to be dispersed. And that's from the federal government. It's designated to be for rentals in Minnesota. That's its job, to get tenants settled up with landlords. And so hopefully landlords will see, I want to get paid. I think the tenant wants me to get paid. So then that'll clean out their balance sheet so they don't have an outstanding debt hanging over their head. Maybe they won't have to file for bankruptcy. Everybody's better off if the landlord and the tenant can work together to try to get this money. And as these abilities to file evictions open up for landlords, I think it's going to change the negotiating posture between the sides. We've had such a long period now where landlords really just couldn't file evictions. It had to be an exceptional set of circumstances where a landlord could file an eviction. Those circumstances are starting to become less exceptional, that are needed, that a landlord must have to be able to file the eviction. So it's going to change the posture, and tenants are going to be more likely to need to open their door because the landlord's going to be telling them, hey, either pay up or else I'm going to go file an eviction, which the notice requires. And again, we'll talk about that in a second. So anyhow, we are now in phase 2 of the eviction off-ramp phase-out process. We're going to talk about all 6 phases, and then we'll put it on a chart so it's easier to understand. But let's go on to phase 3 now. Okay, phase 3 starts next month. There's a lot of 30-day gaps between these phases, and this is our first 30-day gap. This is, once again, non-renewals or lease terminations, not an eviction door that's opening. It's a lease termination and non-renewal door. In my mind, this is the least important of the 6 phases that we have in the eviction process. I don't know that it's going to change the landscape much because of what it allows the landlord to do versus what they had before. But here's what it says. It says that a landlord is allowed to, on August 13th, issue a termination non-renewal for non-payment of rent if the tenant owes outstanding rent and they've been denied their application for assistance through a place like Rent Help. So again, the landlord could give that notice on August 13th. Hey, you know what? The end of September, I'm going to go ahead and make you leave. If you don't leave by then I'm going to probably file an eviction at that point. Which brings us to the next phase, phase 4, which zooms ahead 30 more days. Eric, if you could. Thank you. September 12th. This is a much more important date. Arguably more important than today's date, which is a pretty important date of the 6. So September 12th, the landlord can go file an eviction against a tenant who has applied for rent help assistance, but they've been denied. We don't really have a good sense of what percentage that's going to be at this point. And maybe we'll be able to get something about that sort of information when we have folks from Rent Help actually join us sometime in the next 3-4 weeks. But yeah, a landlord can actually file an eviction versus simply giving a notice to vacate. Now, a lot of landlords at this point, they're going to see that long speech I just gave about landlords wanting to get paid from Rent Help. They're going to have these tenants that have been turned down. So the assistance from Rent Help doesn't look very realistic. So it's very likely this is going to be among the biggest eviction days of the year, September 12th, as far as when landlords are going to file, because many of them will be holding off as tenants have been denied up until that time, and they won't be able to file an eviction until September 12th. And that's when they'll go to the courthouse, pay their $300 and start the court case. The next phase in October is the end of almost everything when it comes to the phase out eviction off-ramp approach that we have. At this point, there's no more requirement for a notice that a landlord has to give for non-payment of rent. There's only one piece left that goes through June of next year, which is that if a tenant has a pending application through rent help, that the landlord can't file or even proceed with an eviction. So if the eviction's already started, based on the language of the session law, it looks like the case gets stopped or delayed or stayed or something. We're not exactly sure what the phrasing that a judge might use in that situation, but it holds up the case for sure. So from October 12th to June 1st of 2022, the only thing left from the eviction moratorium off-ramp / phase out is that a tenant can't be evicted if they have a pending application and the landlord wants to evict for non-payment of rent. Okay, let's go on to a couple of the things that we've been talking about and dive a little deeper into them. The notice requirement to start with. So as mentioned, this lasts until October 12th of this year. What it requires a landlord to do is if they wish to file an eviction for non-payment of rent, they have to give at least a 15-day notice. That notice must state that the eviction moratorium has ended, the total rent that the tenant owes, and where the tenant can go to try to get financial assistance. That notice has to be given in writing. There's some strange language in this session law that honestly attempts to sort of minimize a mistake that the landlord might make if they don't give the notice exactly like the session law is requiring it to be given. It's a little confusing to me because the requirements really are what we have on the page here, these bullet points. Moratorium is ended, I can file an eviction, total amount of rent due, and how to find rental assistance. I've seen a few of these already because landlords have been giving these 15-day notices for tenants that have refused to apply. They still have to give the 15-day notice for that reason. And so I've seen a few of these, and landlords generally are getting these right. It isn't that hard to get right. And one of the real reasons for this notice is that it would inform tenants that have been told for months, well over a year now, hey, you can't get evicted. Can't get evicted. Even if you don't pay your rent, can't get evicted. Pandemic, right? They've been told this for a long time. And it's become not front page news anymore. It's not talked about as much on social media. And there's a ton of confusion about this. I can attest to that from the emails and the calls we've been getting on our hotline that people are trying to figure out what it all means. I gave a landlord speech the other day, and landlords are trying to figure out what this all means. This is not a simple, easy to understand one-step process that everybody's going through. It's a 6-phase over 11-month process that we're all going through and trying to understand phase by phase what the new options that landlords have are. But this notice requirement goes through mid-October. So anytime a landlord wants to file an eviction in Minnesota for a non-payment of rent case through October of this year, they must first give this 15-day notice requirement. Now, this is a complete change from the past. Minnesota has not had a notice requirement as for an eviction to be filed by a landlord. It's one of just a couple of states that doesn't have any kind of notice requirement for evictions. And so this is a big change for Minnesota law, but it does end, it sunsets, as they say in legislative speak, on October 12th, which is when the notice requirement will officially no longer exist in Minnesota, at least the state version. All right, let's go on to the safe harbor provision as well. So as you see on the bottom of the page, the big bold letters, they're bigger than all the other letters on the page, is this protection lasts through June 1 of 2022. Once again, this is where a tenant has applied for help through rent help. We've all heard the stories that it takes a while to get through the rent help system, which is unfortunate, but that's what we have. Maybe it'll speed up as it gets more proficient. But if a tenant has applied for rent help through the rent help system, a landlord filing an eviction for non-payment of rent, the case needs to be paused, for lack of a better way to put it. The only exceptions that we've seen before that are where the tenant is refusing to apply or they've been ruled ineligible, which we'll show you in the phases here in a second when we look at our chart showing all the phases in one spot. But this safe harbor, once again, and this is the big news about I think from the session law, I think this is probably the biggest result that's helping tenants stay in their home and hopefully helping landlords get paid, is this long-term, let's make sure people get through the rent help system because we want to make sure that landlords get paid. Okay, let's go to our chart. And I want to thank Rachel Sterling for putting this together. This is my favorite version of this that I've seen anywhere that's put together. I think it's the easiest to understand. So as mentioned, phase one ended yesterday, right? That's where the landlord had the list of reasons, mostly the same ones from the executive order, where they could file an eviction. We added in that the landlord could file an eviction for non-payment of rent if the tenant was behind and had refused to apply for rent help. There was also the ability to give some notices to terminate the lease as well for material violations. Not as big of an important step at that time, but we're now into phase two. So slide over to phase two. That started
Mike,
today.
I was going to say really quick, phase one didn't really end, but we've moved to phase two, and these, all the rules stay in effect, right? So
absolutely, they're cumulative is the way to really assess these. Landlords don't lose any rights as this phase out happens; they simply gain them. It's hard to really say that tenants are gaining rights throughout these. It really is landlords gaining the right to use the eviction process once again, or ending the lease. None of these really are tenants get new rights. They're landlords regain rights they used to have. But you're right, Eric, they are cumulative. And I apologize if I misstated it that way. I tried to make it clear earlier, but I think I did say it wrong here. Yeah, phase one is over, but those rights that landlords have under phase one remain. Now they get more rights because we're in phase two. This is one of the big days, July 14th. Landlords can now file an eviction for a material lease violation. Once again, these aren't free for landlords. They cost about $300 to file. And if they're going to hire an attorney, that's several $100s more probably. I don't know what landlord attorneys are charging for these cases. Material lease violations in the past, historically, I think landlord attorneys have generally charged more than a non-payment of rent eviction because they tend to be more complicated. The landlord has to prove more. It's not just showing a rent ledger. It's maybe bringing in witnesses and producing evidence that might be shown depending on the kind of case it is. So these aren't the easiest cases for landlords to win, material lease violations by any stretch, but they do have the option to file an eviction as of midnight last night. They can still file an eviction for non-payment of rent if the tenant hasn't paid and they refuse to apply for rent help. The landlord still has to give a 15-day notice prior to that, but they could have given the 15-day notice on June 30th. So I think this is the first day that that's going to be something that's allowable. Tenants that are refusing to apply, landlords can file an eviction for non-payment of rent because of that reason. Moving on a month into the future, at which point landlords can once again terminate or non-renew lease, not file an eviction for tenants that have applied but have been denied help through rent help. As mentioned, I think this is probably the least important of the days on the screen that you see, but it is still one of those landmark points where a landlord does have a new right, a new tool in the box to use. That brings us to phase four, September 12th. As mentioned, I think this might be the single biggest day that landlords file evictions. Hard to know, but it's going to be a substantial increase because landlords at this point can file an eviction against a tenant who's behind on rent and has been ruled ineligible. So that's a pretty big change at that point from where we are today. Once again, the landlord would still have to give the 15-day notice before filing the non-payment of rent eviction. Phase five is a month later into October. And essentially we're back to pre-pandemic landlord-tenant law when it comes to evictions at that point, with one exception, and the only exception that remains is that if a tenant is, if a landlord wants to file an eviction for non-payment of rent, and the tenant has an application pending through Rent Help Minnesota, that the case can't be filed or proceed, which implies that even if the landlord has already filed the eviction, and then the tenant runs to Rent Help and says, hey, I want to file now, that's probably enough to protect the tenant at that point because the case is not allowed to proceed at that point. So those are our 6 phases that we have in Minnesota: our eviction moratorium, phase out, eviction off ramp summary. We do need to talk about the federal rules as well for a little bit. Let's go on to the CDC moratorium. Right, so that shows how far we are in the shaded parts. Thanks, Eric. That this is the active part. In August, in mid-August, the gray or the blue shaded area will go over further. Once again, none of the rights disappear as we go into new phases for landlords. They simply accumulate. Okay, thanks. Let's go on to the CDC slide. So we won't be talking about the CDC moratorium much longer, unless it's in some sort of historical analysis of the eviction moratorium that maybe we'll do at some point in a year or something. We've done a couple of those midway through the moratoriums, and I'm sure we'll do more at some point. But anyhow, the CDC, Center for Disease Control moratorium, was instituted back in September of 2020 during President Trump's tenure. It banned evictions for non-payment of rent throughout the United States. It has been extended 4 times now. However, we've been told by the CDC that when they renewed the latest version at the end of June of this year, so just a couple weeks ago, they stated that this was going to be the last renewal, that after July 31, there would be no more nationwide moratorium on evictions. The Supreme Court heard a challenge to the CDC moratorium on evictions. There have been several court challenges, but one actually got all the way to the US Supreme Court, and the Supreme Court ruled against it 5-4. Ruled against the landlords, I should say, a group called the Alabama Association of Realtors, and allowed the CDC eviction moratorium to remain in place. This is only about non-payment of rent evictions. It defers explicitly in its language to any stronger local protections, whether it's a state or a county or even a city that might have a protection in place. And assuming that it goes away at the end of this month, as it's been promised to do, it didn't end up having much of an impact in this state, not in Minnesota. As mentioned, it defers to any stronger local protections. We've had those in place in Minnesota throughout the pandemic. And so, if anything, the CDC moratorium has served mostly as sort of a theoretical backstop, that if the state eviction moratorium were to go away, that the federal moratorium would still be in place. And other than that, it hasn't really played a major role in Minnesota, but it's still worth noting because this gets a lot more press than the state moratoriums. And so we still get lots of calls from tenants saying, oh, I know that the eviction moratorium ends July 31. What do I do then? And they're right, this moratorium ends July 31, but it's the state off-ramp that really matters more at this point for tenants. And that brings us to our last eviction moratorium topic, which is that we're going to cover before we get to questions, which is the CARES Act. The CARES Act, which is really in the mists of our memory at this point, I would think. This was passed back in March, I think, of 2020. Maybe it was April, but March or April. Very bipartisan at the federal level. So at that point, we had a Republican-controlled Senate, a Democrat-controlled House, and President Trump, a Republican, obviously. And it was very overwhelmingly passed. This had a lot of features to it. It wasn't just about landlords and tenants. It was a stimulus package, some aid for small businesses, very long legislation. It covered a lot of different things, very broad. And it did cover rentals, though. A small part of the CARES Act talked about an eviction moratorium being in place through July 25th of 2020. That's last year. Right, July 25th of 2020, the CARES Act eviction moratorium ended. However, the CARES Act said that after July 25th, if a landlord wanted to file an eviction for non-payment of rent, they were required to give a 30-day notice that they were going to file the eviction. That 30-day notice requirement did not, in the statutory language, did not sunset. Again, that verb that they like to use for legislation. It has never ended. It has never officially ended. I think the only ways it can end are if there's new legislation ending it, I guess, or maybe if a court decides that that's no longer constitutional, I suppose. I'm not sure that any other way that it can. I don't think the president has the power to end it. I guess courts could simply stop enforcing it. It doesn't cover everybody. The CARES Act doesn't. This 30-day notice requirement for non-payment of rent doesn't cover everybody. It covers just CARES Act covered buildings. All right, well, what's a CARES Act covered building? So any rental that has a type of federal subsidy, and the easiest way to understand if it's one of those federal subsidies that matters here is if you look at the legislation called the Violence Against Women Act. VAWA for short. It's got a list of buildings that are covered under VAWA, and the CARES Act specifically refers, if it's a VAWA covered building, the CARES Act covers that building as well. But it's not just those buildings. It's also smaller places where the landlord has a mortgage that's federally backed, like Fannie Mae or Freddie Mac, as they are known in the trade. And so we don't know exactly how many buildings in Minnesota, how many tenants in Minnesota or landlords are covered by the CARES Act protection. We used to think about this a lot more. A lot of this is somewhat unknowable without actual discovery in a court case, very formal approach to litigation. In many other states where the CARES Act has played a bigger role, state Supreme Courts have handed down instructions to lower courts that they were going to require affidavits from the landlord that they had complied with the CARES Act by giving a 30-day notice, or that they weren't covered by the CARES Act. The owner can very easily figure out where their mortgage is from. The tenant figuring that out, again, not without discovery in a court process, it would be very difficult to do that. So we'll see whether or not this plays a role in Minnesota evictions going forward as non-payment of rent cases are allowed to be opened up. I suppose the absolute safest way for a landlord to do things would be to give the CARES Act notice and then the 15-day notice. If they're not sure about what kind of mortgage they have, they could give both. All right, I think that's the stuff that I wanted to cover, and that was nearly 45 minutes. Sorry that went on so long, but there's a lot, and this is an important day. But I'm going to take a break and grab a drink, and Eric's going to talk about some stuff before we get to questions.
Thanks, Mike. Yeah, it looks like we've got some questions that have come in, which is totally reasonable because this is complicated stuff, and that's why we're doing this. We're going to go first to a handful of questions that were submitted in advance, and then we'll move on to those that are in the Q&A. So please, if you have a question, we have more than 45 minutes here, and so I think we'll be able to tackle all of these. And yeah, I hopefully you saw in the chat, I did, as Mike was talking, provide some resources regarding some of the topics he was discussing. Again, on our website, there is a lot of information in FAQ. The timeline that you saw in the slides is up there too. And then we'll also post a recording from today and previous ones up on our website. So with that, we'll move on to some questions. So another Eric, but this one is a landlord, asked if the lease indicates the tenant is responsible for the water bill, but the tenant isn't paying, would that be a material breach?
We're flipping coin. Who's going first?
Oh, I think it's you. I've been talking for a long time. People want a new voice.
Fair enough. All right. So the answer is going to be maybe, and I'm sorry that that's such a typically lawyery answer, but maybe. The actual specific language in the lease is pretty critical here, because the tenant is going to argue that this isn't a material violation, so that it doesn't fall or rise to the level of what would pass under the now available eviction allowances. But a landlord could argue then that it is a material violation. And so I'm sorry to say that I can't give it a good yes or no answer here. It's maybe. Oh, do you have anything to add, Mike?
Yeah, if I had to bet just on what we have from the question, I would say no. I think it would probably take some somewhat unusual lease language to be considered a material breach. I can imagine lease language where it would give the landlord a better argument, but I can also see a judge or a referee in housing court saying, you know what, I think this is really just non-payment and you're trying to sidestep it. So it's not really because the material breach says explicitly, except for non-payment of rent. And so that's going to be where the judge is going to be a little bit torn on that type of question. Like I said, I'd bet against it probably, but maybe is the right answer. It's the only right answer today, I think.
Yeah.
And Eric chatted that the payment would be to a third party for the water bill.
Yeah, I understand that. It's mostly the lease language that is critical more than anything else. Yeah.
And I think another important thing to raise here is that and I should check about zero balance, but I know that rent help MN does cover utilities. So again, it's essentially important to make sure that tenants are aware of those resources. And yeah, I think eligible expenses under zero balance does include utilities that are included in the lease. Okay, next question, Sarah. We think it's from a service provider. If a tenant had a material lease violation from last year, can the landlord evict on that now? No rent is overdue in this situation.
Yeah, so this brings to mind a question about something called a waiver, which is if the tenant has paid, let's say the tenant has caused some sort of material breach, they violated the lease. But then the next month they paid their rent and the landlord accepted it. Has the landlord waived the right, that's the legal word for it, waive the right to file an eviction for that breach of the lease? Now, there are two sort of general types of breaches of the lease. One is sort of a one-time breach, or maybe that happens multiple times, but it's one time and again and again, like a wild party or smoking once in your apartment where it gets discovered would be a one-time breach of the lease. And I think a waiver argument there is better in some ways for the tenant, because the landlord's probably accepted multiple months of rent since then, knowing about the breach. Now the landlord would counter with, well, wait a second, I couldn't evict them for the breach, so what choice did I have but to accept the rent? Well, if you really wanted them gone the minute you could do it, then accepting the rent probably wasn't the right move. The other type, though, is what's called a continuing breach, and that's that unauthorized occupant. You know, somebody's living there, or a dog is living there, and so it's just been happening again and again. Once again, if the landlord has accepted rent knowing about that, the tenant might have a waiver argument. And there's some case law in Minnesota that says that if a landlord wants to start enforcing a continuing breach that they haven't been enforcing in prior months, they need to warn the tenant, maybe with as much as 30 days notice, that, hey, you know what, you've been breaching the lease and I've been accepting rent knowing about it, but I'm going to stop doing that. We're going to start enforcing our rules starting 30 days from now. So you're warned. So anyhow, can the landlord file an eviction for this? Sure. A landlord can file an eviction anytime they want. Whether they'll win the case is a different question. If I were a landlord attorney, I'd be cautioning my client, this isn't a sure thing. And lease language, once again, is going to matter quite a bit in this situation. Some leases have what they refer to as an anti-waiver clause, which sometimes can work, but not always. So it can be a little bit complicated.
All right. Chris, a landlord, has a question. How long is the 15-day notice good for? Is it until I as the landlord have to give it or how long is it good for until I have to give it again as a landlord? Can I file an eviction 30 days after the 15-day notice was sent?
So the law isn't super clear on this. It's what it specifically says is that a landlord has to give at least a 15-day notice. So the cautionary tale there, though, is that part of the notice also has to include what past due rent is. And so if that number changes, then the notice should be reissued, because then the number is going to be different. And so so I would say that it's likely that a new notice is going to need to be given, just because generally every 30 days, the rent is the rent due or past due is going to change. So it's also to the landlord's benefit to reissue that notice, just because, you know, that way your tenant knows exactly what it is that they owe, versus, you know, it's like, well, are you know, charging me another rent or another late fee, or how is this all adding up? Because as Mike was saying earlier, sometimes this just, you know, everything gets lost in the shuffle of, you know, numbers that are just escalating dramatically and quickly, and you just, you know, stop opening the letters, right? So how often does that happen? You know, avoidance. So I would say that in the grand scheme of things, if you are not filing an eviction within those 15 days, that it would be within your, as a landlord, best interest to give the notice again.
And here I'd recommend to landlords that although the session law only requires that you state the total amount of rent due, it doesn't say that you can't list other things that are due as well. And I think it's in the landlord's best interest to list the utilities, list the late fees, list whatever other debts the tenant owes. If I were in charge of writing this law, I would have, and there was an earlier version that did have that was known publicly, that did have the total amount due. It didn't have the word rent in there. So it's sort of limited in what's required by the statute. But again, what does the landlord really want here? If they want to win an eviction, then I guess just listing the total amount of the rent due is enough work. But if you want to get paid as the landlord, you should list not just the rent that's due, but the total amount that's due and break it down. So it's easy to understand what each piece is about.
All right, and I did put up that slide again just for that information. A B asks, what can a landlord do to find out A, if the tenant has applied for emergency rental assistance, COVID-19 emergency rental assistance, and B, the current status of the tenant's application?
And this one, I think I'm going to actually hand over to Rachel. She works in this world more and is on more committee meetings and hearings than I am on this. So Rachel, do you mind handling this one?
Sure, not a problem. So for the first part, a landlord, so part of the release rent help MN process also requires the landlord to set up essentially a profile with Rent Help MN that then they get connected with their various tenants who may have applied as well. So that's one way that a landlord should be able to see which of their tenants have actually applied. I'm honestly not certain what step of the process the tenant is in, where along that line that they actually get connected. We aren't Rent Help and experts, so I don't dive too deeply into all of that detail, but I do know that the landlord does need to have a profile set up and then the tenant, and they should be connected at some point. So the landlord can find out that way. And then the current status of the tenant's application, there's a couple different ways that they can do that. If they applied online or have an online login to the Rent Help MN portal, they should be able to get a confirmation. So when they first apply and they are first accepted into a pending status, essentially when they hit submit button, they should get a confirmation screen that they can print off or email to themselves. They should also get an email from Rent Help MN, basically with a confirmation letter saying, you as of X date, you have applied. Otherwise, if they don't have that technology, then they should be able to call 211. And 211 will be able to confirm the status. Now, my understanding is that 211 won't do that for anyone besides the applicant. So like a landlord couldn't call 211 and confirm that, or a service provider or an attorney. They won't give that out to just anybody. It has to be the applicant. And I believe that 211 is mailing out confirmation letters as well, but I also understand that that's a fairly slow process. So that is what I know.
Yeah, and then I'll just note too, the zero balance project is of course landlord initiated, and so there's also an online portal there where they can check the status of their application, what's going on with it. And of course, again, we are going to have, let me go back to the screen here. Next week, we're going to have a guest speaker from either or perhaps both Rent Help MN and Zero Balance. And so we'll have one of them on at least next week, and then in a future week, the other, if they're not in the same week. So save some of your questions for that too, because we're not necessarily experts on those programs. There's one question I saw back in the chat that we'll get to really quick. Somebody asked, what is the timeline for phase one? Time frame for phase one.
All right, Eric, can you just take us to the chart page, and we might just leave it there for the rest of the speech because it's going to be a lot of the questions that I've seen that have come in since we started. So phase one, the timeline is, that was the question, right? What is the time frame for phase one? Yeah, phase one is over. As we talked about a couple times now, it's cumulative, so landlords don't lose the rights they gained in phase one, but it ended as of 11:59 last night when we ventured into phase two. And it simply gave landlords the same rights they had under the executive order to file an eviction, minus the family member / landlord wanting to move in exception, but added that a landlord could file an eviction for non-payment of rent if the tenant refused to apply for help through Rent MN, although they'd still have to give the 15-day notice. So in theory, that might be today where landlords' ability to file an eviction would actually finally be realized. But phase one officially is over as of yesterday, but as we talked about, those rights don't get extinguished. They start to build on each other. So phase two just adds to phase one's abilities that a landlord had.
All right. Now we're moving on to questions in the Q&A system. So we've got 14 there, it says. We'll start plugging away at those. We've got a little over half an hour. So first, an anonymous question we have from a landlord, it looks like. This landlord has every month received more tenants notifying them that someone told them to apply for aid and they're going to stop paying their rent even though they have the money. Is there someone checking the system for abuse?
So I'm going to say that Rent Help MN, one of the reasons it is taking so long to process the applications is they do have a very rigorous confirmation of like income and this is the money that's owed and things like that. So the you know, if the tenant is not actually income eligible, if they aren't at 80% or less of the area median income, then they're not going to be eligible for the program, and they do need to submit documentation that shows their incomes and things like that. So that is part of that process. Otherwise, if there is fraud that's being suspected, Rent Help MN does have a report fraud link that can be used to do that. You know, we've been getting kind of both, you know, stories from both sides of that, as well as that, oh, tenants are, they just decided, well, I'm just going to use the government to pay for my rent, I just can stop it. But I've also heard of landlords who are jacking up the rent for their tenants because they're like, well, I can get more money out of the government this way. So I would say that if there's potentially fraud or anything like that on either side, one, the system is set up to track or to be able to catch that before funds go out the door. But if there's some concerns, then you can report it to Rent Help MN. I'm not as familiar with if I'm sure that Zero Balance Project has a similar option. I'm not as familiar with that program yet, so that's what I know there.
Yeah, and I guess, a key thing there is the program is taking a while because there's an application process and they have to verify things. And so it's difficult, I think, from perhaps this landlord's perspective. I'm not sure how somebody has the money to pay the rent, right? They might be using their money for other essential needs. So, all right. Question from Kelly. I'm a youth advocate and one of my clients just received a 15-day notice of the landlord's intent to file for eviction. The list of reasons for this notice only mentions things related to being behind on rent. There's no notice of any material breaches. Does my client need to report this notice to Homeline or someplace else, or do I advise them to wait and let the court hopefully turn the landlord away?
You're on mute, Mike.
Sure am. A couple of things here. First off, we look at our chart and the 15-day notice is only required for non-payment of rent cases. That's the only time that the 15-day notice is actually critical for a landlord to give. But right now, a landlord can only evict for non-payment of rent if the tenant refuses to apply for rent help. They won't be able to file an eviction for a tenant who's been ruled ineligible until September 12th. So if I was given a chance to say just one thing to this tenant, it's, hey, make sure you apply for rent help right now. And then when you do, get the proof to the landlord. Get the proof to the landlord that you've applied for rent help, whatever you can get them. So they know that, or at least they should know that they can't file an eviction against you while your case is pending through June of next year. I absolutely would not wait for the court to hopefully turn them away. From what I understand, the court is not just turning away cases as they were during the pandemic. They're letting cases get filed and then they'll decide what to do with them once they're filed, like they always used to. So counting on the court to solve that problem, well, they might get it right. Yeah, again, apply for rent help if the tenant's behind, and then tell the landlord exactly about this. And they are, of course, welcome to contact us as well. We'll be happy to walk the tenant through this, talk about why it's to their advantage to file for help from rent help, and hopefully that'll convince the landlord to back off once they get the proof that the tenant has applied.
Right. Question from Therese. Therese, if a tenant is denied by Rent Help MN, can they apply to the Zero Balance Project?
So the Zero Balance Project is specifically for landlords to apply for assistance. The tenant will need to also like fill out some paperwork, but the actual application process is for landlords, and it's through the same funding as the Rent Help MN COVID-19 emergency funds. So and those are given by the federal government. Those are not necessarily state specific. So yeah, short answer is that if the tenant is denied by Rent Help MN, they aren't eligible to apply for Zero Balance because their landlord would have to do it.
I also think, again, Zero Balance is only for Hennepin, Ramsey, and Dakota counties right now.
Yep, excellent point.
And you're as Rachel said, they're the same program. I believe the income thresholds are the same. So that might suggest they may not be eligible, but it would be on a case-by-case basis, I suppose.
Yeah.
An anonymous question: is there a notice required in St. Paul when planning to file an eviction for non-payment in a situation where the tenant won't complete the rent assistance application?
I don't think there's any kind of St. Paul specific notice requirement. The 15-day notice requirement is a statewide notice requirement. The CARES Act 30-day requirement is every building in the state that's CARES Act covered, but it's not St. Paul specific. St. Louis Park and Minneapolis both have enacted recent notice requirements for a landlord to file an eviction in their cities, which don't play much of an important role today because we have this 15-day notice requirement in the state. But when the 15-day notice requirement goes away in October, maybe we'll be having a session on those and how those have a big role. I do know, looking at the Minneapolis ordinance recently, that it doesn't require just that the landlord name the total amount of rent due. I think it has the total amount due listed in their notice requirement, which again is how I would write it if I were writing that law. And so that's the one key difference, but there is not a St. Paul specific notice requirement to file an eviction.
And there, I think both the Minneapolis and St. Louis Park ordinances, in addition to the little bit more detail on what's owed, like the Minneapolis one also requires some other information be in the notice about where the tenant can access other resources, not just 211 and Rent Help MN, but other services like legal supports and other.
Yeah, so a Minneapolis landlord is well served to look at that ordinance first before they start giving notices, and in St. Louis Park as well. Tenants can always have more protection from a city. A city can't take away a statewide protection, but they can add more protection for a tenant if they wish.
Right, and I will post in just a moment here, because as of July 7th, the city of Minneapolis did post their ordinance. It's ordinance 244-26.2060. I'll put a link in the chat.
Those of you that have never tried to look up a city code, trust his link. These are not easy things to find. I'm a lawyer, and trying to find things in city codes can take much longer than it ever should for everybody.
And then
Okay.
bookmark it.
Yes, this is a direct link. 1 second here. I'll ask the next question, then I'll do that. Anonymous, an anonymous landlord. How do we verify tenant is eligible and not just saying they have applied and then stalling application by not uploading documents as a stall tactic?
Okay, so it sounds like there's a couple of things to kind of unpack here. So verifying a tenant is eligible isn't necessarily going to be the landlord's job. That's more the program's job to verify. But the standard is that the tenant needs to be 80% of, or make 80% of the area median income or less to be eligible for the program. As well as a couple of other things that are laid out in the Rent Help MN website. Fairly, just say, am I eligible? And they'll list all of the things. So if they're just saying that they applied, they kind of, I touched on it earlier, the various confirmation letters and such that a tenant can access or utilize to prove that they have applied and that they have a pending application. It's definitely within the tenant's best interests to provide that proof because as Mike was talking about earlier, under phase 1, if a one of the exceptions for the eviction restrictions is that if a tenant who owes rent refuses to give their landlord the information needed to apply, or excuse me, who refuses to provide proof that they applied, would be a potential eviction action. So it's in the tenant's best interest to provide that proof if they've got it, and if they don't have it yet, then they should apply for it. And then the whole stalling application by not uploading documents portion of it, I mean, I don't know how to answer that completely, just because for one, that's something that the Rent Help MN program is really the one in charge of handling. So if they have a pending application under the law, they have a pending application and they have protections until June of 2022 if they are behind on rent. And so that's essentially the outlines of what a tenant's protection is if they have a pending application with Rent Help MN or through any of the other programs like Zero Balance Project or something like that. So yeah, I don't know. And it's honestly not within the tenant's best interest to stall this process. Like, you know, getting that debt paid is such an important thing to do that I don't know why necessarily a tenant would want to delay that. But per what the question says and states, a tenant has protections until June 1st under the statute, or session law, I should say, not statute.
All right, thanks, Rachel. So Kate is asking, currently, if someone has been denied assistance from Rent Help MN, they cannot technically be evicted. The landlord would have to wait until September 12th, even if the tenant has already been denied from Rent Help MN.
Right, and that's why we have our chart up here on the screen. So we look at the chart, and I think that Kate's question is right. I think she's got it, that a landlord cannot file an eviction against the tenant for non-payment of rent if they've been denied for the rent help assistance until September 12th. It's only that tenant who refuses to apply for the rent help assistance right now that a landlord can file an eviction against them for non-payment of rent. So that's right, they'd have to wait until September 12th, even if the tenant has already been declared ineligible for the funding. I think that's the right answer.
And just a thing to add here is that, again, the session law points out that the rental assistance programs that are eligible within this law are COVID-19 under the two federal laws that brought in the approximately $670 million to the state. There are other programs. Counties have other emergency financial assistance programs. Places of worship sometimes do. Community action agencies do. They all have often different income guidelines and requirements. So, you know, those programs don't kick in the June 1st protection, but you know, that's what we're telling tenants is that, you know, if you're denied somewhere, you might be able to get funding in another location. I mean, the point is to get the rent paid, and so try other programs. And 211 is a good place to go there. All right, a question from Jake. Is there any notice requirement if we are filing for eviction on material breach and not rent delinquency? I understand it would be prudent to give an opportunity for voluntary surrender prior to filing, but is there a requirement?
So under the statute, the notice requirement, that 15-day notice requirement is only required for non-payment of rent cases. So it's not required for material breach or the other eviction actions listed here under phase 1 or phase 2. So no, but as Jake says, it's probably a good idea to give some sort of notice. Most landlords that I'm aware of would prefer to avoid the eviction process and just terminate a lease, and that requires some notice of termination and such. And that way, either the breach can be rectified and things can continue on, or you know both the landlord and the tenant don't have to deal with heading to court. So I agree, Jake, that some sort of notice would be very much encouraged, but not necessary under the session law.
All right, thanks, Rachel. Kimberly asks, how long do landlords have to give tenants to get their assistance through rent help? We have several who have not uploaded documents, so it's been pending since April.
I'm not sure that the law specifically really tries to answer that question. It simply refers to these applications as pending. And so looking at the phases where we get anything close to an answer to that question is, all right, the tenant clearly applied, so they were not refusing to apply. So a landlord couldn't file an eviction against them right now for refusing to apply. The next really important phase in that non-payment chart is September 12th, where the landlord could file an eviction if the tenant has been ruled ineligible or denied. And I'm not sure if there's some sort of activity that the tenant has to maintain to keep the application pending. If they have to check in every 2 weeks or something, I don't know of anything like that, any kind of requirement like that. And so it might be something that's a little bit difficult to prove, but I think that we've seen some people deemed ineligible, that they've been denied. The tenants have been denied already. So it's something that can occur. I'm not sure if landlords get informed of that. Do you know, Rachel?
And I think it mostly has to do with that landlord portal. I don't know if they're, you know, I know that the tenants are listed who get attached to the landlord. And I believe, but I don't know how quickly or their status is updated there.
All right. And again, we apologize. We're not experts in the rental assistance programs, but we will have in the next week and over the next month, people from Rent Help MN, the Minnesota Housing Finance Agency, and the Zero Valence Project on. And as soon as we confirm the dates for each of those, we'll be sending out a widely spread email. So, okay, anonymous question. Still confused about filing eviction for non-payment of rent. Since the CDC order is in place until July 31st, can I, as a landlord, not file eviction for non-payment of rent? And in this case, the tenant is refusing to complete the application, rent help application, I suppose.
I think that one's mine. So that's a great question of how the CDC order and the Minnesota statute play together. So the CDC moratorium is effective until July 31st. That's correct. To define protections under the CDC moratorium, a tenant would have to fill out a declaration stating that they have attempted to get what emergency rental assistance is available, that they have been negatively impacted by COVID-19, and that a couple of other things that they have to essentially declare, and then give that to the landlord to prevent an eviction. Now, the as Mike was saying earlier, that protection doesn't really have much bearing in Minnesota because the current session law, the off-ramp laws, are more protective than the CDC moratorium law is. So because the non-payment of rent evictions, there's one, if the tenant is refusing to complete the application, or if the tenant is refusing to apply, just carte blanche, they just refuse to apply, they don't want to go with the program at all, then they wouldn't really be eligible for the CDC protections, because they wouldn't be able to say that they'd tried to apply for all of the emergency assistance available for rent. And that falls under phase 1, allowing evictions for refusal to apply. If the tenant is refusing to complete the application, it kind of goes off the last question we were talking about the tenant not uploading documents to string the application process out. Again, the Rent Help Amend program is the one in charge of that. It would be a great question, I think, to ask next week, or when we're able to get the program administrators, those experts in to discuss that process. But again, under the session law, if a tenant has a pending application with a COVID-19 emergency assistance fund, then they are protected from an eviction for non-payment of rent until June 1st of next year.
All right. Question not related to the phase out here from Anonymous. Could you explain the rent escrow process? And could a tenant that is month to month on a month-to-month tenancy or term use this process to pause a notice to vacate after the October deadline?
Okay. So a rent escrow is a court case the tenant files against a landlord, typically because there are repairs that aren't made, something like that, where the tenant will pay their rent to the court, and the court will hold on to the money and listen to the tenant talk about why they are asking the court to intervene, what kind of repair problems they are, and how severe they are as well. I'm not exactly sure how that pauses the notice to vacate after the October deadline. That doesn't really fit in my mind with something that a tenant could use somehow aggressively to stop a landlord from being able to file. They'd still be paying their rent. The tenant would still be paying their rent. They'd be paying it to the court. The tenant is supposed to pay whatever rent is due to the court in order to be able to file a rent escrow. So I'm not exactly sure how that does much for the tenant to slow down the landlord's ability to either give a notice to vacate or to file an eviction for non-payment of rent past October. I'm not sure I follow the question completely, but any theories?
I think they might be asking, like, say a landlord gave a notice to vacate because they just didn't want to renew the lease on a month to month. Could a tenant potentially stall that? So they got it for they have to be out by November 30th, on October 13th. And I think what they're asking is, could a tenant file a rent escrow and then delay that date until the rent escrow action or case is done?
Yeah, I don't think that would really hold up the notice to vacate at that point. I mean,
Yeah,
a tenant could argue that it's retaliation for a tenant filing the rent escrow, but that would have to predate the notice or the eviction by the landlord. The landlord can't retaliate against something you haven't done yet. So I'm not sure that it really does much for the tenant.
Yeah, because they're basically two different silos. The rent escrow is about repairs that need to get done, and that the landlord is apparently not doing. And the notice to vacate, I mean, it might be in response to a tenant saying like, fix this, and the landlord's just done with it. But those are, at least under the law, my understanding is those are two very different areas. And so they don't have much bearing on each other, as you said.
All right. 10 minutes left, six questions. See if we can get through these. An anonymous question. Let's say that all phases have passed and then a tenant, so all phases means we're in June 1st of 2022. Let's say all have passed and then the tenant applies for help through Rent Help MN for a recent reduction in their income. Does the pending application still help the tenant and prevent an eviction from being filed, or does the application have to take place within the phases?
The law.
I was going to say, if all the phases are done, we're on June 1st, but maybe they're asking about through phase 5. I'm not sure.
Yeah. Well, because if it is through June 1st, then I don't know. It depends on if the program is still running or not at that point, or if they've run out of money. I mean, there's a lot of potential future impacts that could impact that question. But under the statute, there is the protections for a pending application end on June 1st, 2022. That doesn't mean that if the program is still being processed and going and it's taking longer than anticipated, there may be additional protections that get put in place, but that is just purely speculation. If there's something that, if you only mean through the October 12th deadline, phase 5, then yes, the protections would still be in place even if a tenant applies on October 13th for rent help. Then they would then have a pending application and then have protections under this session law until June of 2022.
Right. And just a kind of some context for this too is that there's hundreds of millions of dollars in these rent assistance programs. The dashboard for Rent Help MN says about 160 million has been requested through applications. So even if they pay all that out, there's still more left, and so that's why this goes until June 1st. Is that there's plenty of funding available there. Okay, next question is from Jake. Could we combine the CARES Act notice and the Minnesota notice into one and serve it 30 plus to knock out 2 birds with 1 stone? I'm assuming Jake's a landlord.
Yeah, my big concern about this would be the naming of the rent, because you have to name the current amount of rent that the tenant is behind, the total that's due in rent. And so you'd have to time it really well and maybe have a month with 31 days in it only, where you could make this work, where you could give a 30-day notice where the rent would be the same amount due within that 30-day period as it would be when the 15-day notice was up as well. So I'd probably recommend giving a 30-day notice and then a new 15-day notice when you're 15 days in, just because you're more likely to be closer to the time you'd be filing an eviction. And then you'd name the total amount rent due in the 15-day notice, which is going to be closer to accurate. I mean, there are going to be landlords, if they think about this seriously and look at the rules, they're going to say, okay, when do I want to file an eviction? Maybe the most common evictions are going to be filed between the 16th and the 30th of the month, because that's when the notice that they gave would have the total amount rent due. Whereas evictions between the 1st and the 15th are a little bit logistically more difficult because the rent amount has changed. In traditional approaches in courts, the court has always allowed landlords to essentially amend their complaint as rent has come due when a month has passed by in the eviction court process. It's not explicitly covered in the off-ramp language, so that's not a sure thing, but it's a decent bet that the courts would simply allow a landlord to modify their 15-day notice, I guess. When they file the actual eviction, a landlord doesn't just give the 15-day notice and staple it to the papers. They'd still need to say how much the tenant owes. And most landlords do list everything the tenant owes at that point, including the court costs. which are typically tacked on to an eviction as well. So there's a lot of different pieces of this from a landlord perspective. But if I were a landlord just trying to do this on my own without a lawyer, I'd give a 30-day notice, and then I'd wait 15 days and give a new 15-day notice that has the total amount of rent due. In fact, as I mentioned earlier, I would add all the other things that are due as well, in hopes that you actually get paid.
All right. An anonymous question. So in phase 4, the landlord can only file an eviction if the tenant has been denied from rent help MN. And then in phase 5, the landlord still can't evict the tenant so long as their rent help MN application is pending. So the only difference between 4 and 5, phases 4 and 5, is the pending status of the application at rent help MN.
So for non-payment of rent, sure. The ineligible status, is for phase 4, the September 12th date. You can evict for non-payment of rent if a tenant is ineligible. On October 12th, basically almost everything else opens back up. There's only that one lingering exception of non-payment of rent cases where the tenant still has a pending application. So I don't know, again, we don't know how fast the program is going to go, and but essentially once that pending status goes away, then it's the protections leave, and then after June 1st of 2022, any protection that's in place for a pending application, I think the hope is that there won't be any more pending applications after June of 2022, but that will remain in place until then.
Right. Could another anonymous question, could your 15-day notice include a statement that includes the next upcoming month's rent?
There's nothing in the law that says that you can't include that. So I don't see much of a downside to saying that. I mean, it only requires the total amount of rent past due. And at that point, when you're giving the notice, it's not past due, but it doesn't say that you can't list that. And so, again, I'm not sure that I see a real serious downside to that. I'd probably say on this date, this additional amount will come due. So it's really specific and clear what you're referring to there. You don't want to just write down 2 numbers and not explain them. You'd want to say why it's going to increase on that date. And you might say that 5 days later that it's going to go up, with the late fee added on as well, too. If you're going to be that thorough, then you might as well be that thorough.
All right, a couple more here, and we got 2 minutes left. I'm going to just put up the information about the upcoming weeks here too. But another anonymous question. We have a tenant who supplied us with proof that they started an application in April and they did not move on, and then did not move on. So can we now non-renew them if they don't follow, or not now? Can we non-renew them if they don't follow through with the application?
I guess I'm not certain what they mean by that said that they did not move on. Is the tenant like physically moving on, or is it that they haven't uploaded more documents to the application?
I think that's what it means.
Okay. That's what I thought maybe too. So, and the law just says if there is a pending application, then the protections are in place until June 1st of 2022. So non-renewals for non-payment are not allowed until basically that point. You can't evict somebody for non-payment of rent until, and when they have a pending application, until June 1st of 2022.
All right, and another anonymous question is refusing not to, and this is similar to previous questions, I think, is refusing not to upload documents and provide the information requested, I assume through Rent Help MN, does that count as refusing to apply? I'm guessing this is a landlord, so their tenant have told them that the tenant makes too much money and they know they won't actually qualify.
So all we can really do is tell you what the law says here, because we don't have courts that have interpreted this yet. And what the law says, this is just reading it straight out of the session law. The tenant refuses to apply for assistance through the program, that's one way a landlord could win. Refuses to provide information needed by the landlord to apply for assistance on the tenant's behalf is number two. Or this is the third one, refuses to provide the landlord with proof that the tenant applied for assistance through the program. Those are the only things that allow a landlord to file an eviction right now for non-payment of rent. It's got to be one of those. Now, in the question you're asking, they're not uploading documents. And so I guess the legal term for that might be that they haven't perfected their application. Would that be an argument? I suppose. I'm not exactly sure how well it does for a landlord. A court might say, wow, I looked at the program myself and this is a little bit dizzying. I think anybody'd be confused. Tenant, I'm going to give you a week to get the paperwork uploaded and then come back. I mean, that could be a way that a judge or a referee tries to solve that problem. But all we can say is what the law says. And until we get courts interpreting what it means, it's nothing but best guesses. They're informed guesses, but they are best guesses.
All right. Well, that was perfect timing. We somehow miraculously got through all those questions right on time at 3 o'clock here. So thank you both Rachel and Mike for covering the details of the phase out and answering these questions. And thanks everybody for participating today. Again, on our website, at these links, you can get resources about the phase out and sign up for future webinars. Sorry, not tomorrow, but next Wednesday, we will have another webinar, and every Wednesday until at least mid-August, and those links for registration are on our website. We'll in the next week, we'll have somebody either from Rent Help MN and or the Zero Balance Project on to cover those programs and answer questions. And then 2 weeks from today, landlord attorney Kim Tennyson will join us to bring that perspective from a landlord attorney. So sign up on our website, and as always, thank you for joining us today. We'll call it a day. Thank you.